Minion, as the movie Haq becomes a talking point, there's a big debate now on laws versus tradition. The Kerala High Court has ruled that if a Muslim man wants to register his second marriage under the Kerala Registration of Marriages Rules 2008, while his earlier one is still in existence, his first wife should also be heard on whether she agrees to it or not. Let's go across to Dipankar, who's joining us on the broadcast with more details. Every time any such case reaches the court, it becomes about personal laws versus, traditions.
Well, yes, this ruling has come from Kerala High Court, where we can see the petitioner had argued while this matter was being heard before the Kerala High Court that under the Muslim personal law, 4 wives are allowed to a Muslim man. However, the court has very clearly stated that if there is a first wife who's living, she has to be given an opportunity to be heard, and she has a valid reason, and if she raises some grounds which says that the second marriage is invalid, that has to be heard and that has to be taken into consideration before registration of the second marriage. So this was a very clear ruling, very clear statement that the Kerala High Court has given, that before the registration of the second marriage, the first wife should be heard. If she is living, then the first wife should be heard, and she should be given a chance to represent herself before a civil court. That was very clearly stated when the Muslim man had approached the Kerala High Court challenging the order of a registrar who had denied to register the second marriage. Right. So this is very clearly it has been stated, and
since it will become about personal laws versus the law of the land. I am being told that the court has also said that second marriage was permissible under the Muslim law, but only in specific situations, and that the first wife cannot be a mute spectator to the registration of her husband's second marriage. And on that ground, on that basis, the court has refused to entertain this plea.
Well, yes, it has been very clearly stated that she has to be given an opportunity to be heard. If there is a first wife who is living, then and if she says that the second marriage is invalid, then it has to be, then her submission is to be taken into consideration before the registration of the second marriage. This is what the Kerala High Court has very clearly stated. The Kerala High Court has also gone on to say that if the if the Muslim man is not able to sustain the wife, then the second marriage would not be taken into consideration.
Right.
And any grounds which the first wife raises will have to be taken into consideration by a civil court.
Absolutely.
Before registration of the marriage, before the registrar.
Right. Dipankar, stay on with us. We have activist Brinda Adige joining us in the broadcast. Your views, the Kerala High Court has said, and this is in case of a Muslim man's second marriage, that the views of the first wife have to be heard. She cannot be a mute spectator, a silent spectator, and witness the registration of her husband's second marriage.
In one way, the Kerala High Court's ruling is correct and as per law. But we need to also understand that asking the first wife to come to court and say, give your views or opinions, and let us assume that in order to have the husband continue to come to our house, this lady says, I have no objections to him marrying again. That is also wrong, because you're pushing the woman to make a statement. We have a law against bigamy. So the second marriage shall not be registered. That should be the final verdict of the High Court, and not say that, just because you're continuing marriage with this woman and let her come and give her say in the court, because that is pushing the woman to a corner. And we know that so patriarchal, and the Muslim community is even more so, that her family will force her and say, go and make this statement publicly in court so that he can go and get married. And that is unacceptable.
Right. Well, the judge did say that religion is secondary and constitutional rights are supreme. And the ruling came when the man and his second wife moved court to get their marriage registered. That's when the court said this. Stay on with us, Brinda Adige. We also have activist Rahul Ishwar joining us in the broadcast. Your views, Rahul Ishwar? Can you hear me, Rahul Ishwar? Okay, let me go back to Brinda. Brinda, will this then become about the personal laws versus the law of the land versus the Constitution?
Exactly, because the Constitution is supreme, and under the Constitution, the first marriage is final, legal, registered, And nothing until and unless there is a divorce. Not under the customary laws, but under the law of the land. If there is a divorce that has happened, then he can go forward and register, marry, whatever. But in this particular instance, looking at these things, the court must, without any excuses, rule that as long as the first marriage is on, there cannot be a registration of the second marriage, irrespective of what their religion might say. The court must not push the woman to come to court and say that she has no objections, because then that would be denying her the complete independence to actually speak.
All right, Brinda Adike, thank you very much for joining us in the broadcast with your views. Thank you to Dipankar as well for getting us the inputs. We're moving